So we're going to talk now about criminal procedure, making sure it's a fair process under the Fifth Amendment. So we just talked about Fourth Amendment gives us a right to protection against search and seizure. The Fifth Amendment says, when we looked at this earlier, here's that part about the takings clause. They can't take your property unless it's for public use and they've paid you. Up here it says, you know, with regard to crimes, we have things like double jeopardy. You know, you can't have a double trial. We'll talk about that in a moment. You can't be put on for a trial for the same offense twice. You can't be compelled in a criminal case to be a witness against yourself, so self-incrimination. We're going to talk about some of these rights we have that protect us, that give us a fair trial under the Fifth Amendment. Before we do that, I want to talk to you about a famous case called Miranda versus Arizona. Raise your hand if you've watched TV before and you've seen them arresting someone and saying, you have the right to remain silent. Anything you say can and will be used against you in a court of law. And if you need an attorney, we can provide one for you. Raise your hand if you've seen that on TV or heard of that before. Who knows what that's called? Miranda Rights. But now you all get to know where it came from. This is the precedent that created Miranda Rights. This is the case. Miranda versus Arizona. So there was this person named Ernesto Miranda, and he was a mentally ill indigenous citizen of Mexico. So isn't this cool for Ernesto Miranda? He created Miranda Rights that we use now in every state and we see on TV. He's infamous. He's famous for this crime now. So Ernesto Miranda is an indigent citizen of Mexico. He gets pulled over in Arizona. The Phoenix police arrest him at his home. And they bring him to a police station. And there's a rape victim. And usually they'll say, hey, can you identify your assailant? And so the rape victim says, yes, it was him who did it. They'll line them up next to like a couple people and she'll say, out of these 3 people, it was him. Okay, so she said, this guy raped me. That's a really serious crime, right? Would that be a felony or a misdemeanor? Felony, yeah, it's a pretty serious deal. And in Maryland, it absolutely is. And so 2 hours later, you know, the police officers, they take him into an interrogation room, and they don't tell him he has a right to a lawyer. And so they start questioning him, and 2 hours later, the officers emerge. They have a written confession by him. And in that written confession, there's a statement. There's a typed paragraph stating the confession was made voluntarily. And then there's a statement that says he has full knowledge of his legal rights and understands any statement he makes can be used against him. So the procedural history of this, at trial, the judge admits this evidence. If we wanted to exclude it, what rule would we use? Exclusionary rule, right? So this is one of the issues that could be appealed. The attorney presents it, and the judge allows the confession to go in, and even when he appeals it, all the way to the highest court in Arizona, they confirm this conviction. They keep allowing the confession. Remember, Miranda is innocent until proven guilty, right? Yes. Here's a good way to prove someone guilty. There's a written confession, and on top of that, the officers who did the interrogation are testifying against him and saying he made a verbal confession as well. We have both. Someone saying, I committed a crime, sound like a good way to get 12 people to agree they're guilty? Yes. Yeah. And so he's, guilty all the way up through the appeal system. This is such a big deal that it went to the United States Supreme Court. So just like you're looking at United States Supreme Court cases that happened in the past 5 years now for that upcoming assignment, here is this huge case where the Supreme Court saying, should this confession be allowed? They're not looking at whether or not he should be convicted. It seems like he's guilty, right? Mm-hmm. They're looking at, should this have been allowed into the courtroom? Was it admissible? Raise your hand if you think they should have admitted this confession. No one thinks so? This guy's guilty. He raped someone. I'm mad at him. Okay, why not? Why should they not have admitted this? What's the problem here? So just raise your hands. So Eduardo, he doesn't have to testify against himself. Did he do so voluntarily?
I think so.
Seems like it, but that's a really good point Eduardo's making. Was this really voluntarily, or did he seem like he got kind of forced into it? Under the Fifth Amendment, you can't be forced to self-incriminate yourself. So he needed to be willingly and voluntarily doing this. You could argue he was not. Anything else seem unfair here? Remember, due process is about being fair.
He didn't have a lawyer.
Sinya, he didn't have a lawyer. Okay, we're going to see under the Sixth Amendment, you're allowed to have a lawyer present at all important stages of a trial. Do you think a questioning stage with the police officer would be an important part?
Yes.
Did he know he had a right to a lawyer?
No.
No. So he never knew to ask for one. Anything else seem unfair? Where's he from?
Mexico.
Mexico? What language do you normally speak if you're born in Mexico?
Spanish.
Spanish. What was the confession written in?
English.
So do you think he understood the confession? Not necessarily. It was in English. Did he know what he was signing to? Maybe not. He might not have had English as a first language. He might not understand it well. I wouldn't understand if someone put that in Spanish for me what I was signing. Don't sign it then. And then on top of that, he had a mental capability. He was mentally ill. Could he comprehend really the consequences of his actions?
We don't know.
Maybe not. We don't know. Maybe he didn't understand what he was doing. Doesn't really seem fair, right? So that's what the judges said. This is where the Miranda Rights came to be. They said you should be told your rights, that you can have an attorney present in all important stages. He should have had the opportunity to ask for an attorney, and he didn't even know that, right? And they argued, like Eduardo said, that it wasn't voluntarily, right? The fact that he answered some questions doesn't mean that he's not allowed to, say, I need an attorney now, and get one. So an example of this, my husband gets murdered. I'm super upset, right? Anyone seen the movie Gone Girl or read that book? Okay, so I'm super upset, and I go in, and I'm upset. There's no reason why I can't help the police officers. They're asking me questions. Where were you on the night of October 13th? And, I'm going to tell them, well, I was at my sister's house, blah, blah, blah. And then I might start feeling like, hey, I'm cooperating with the police officers, but it seems like they think I'm a suspect, which I kind of am. If it's my husband, usually, that's one of the people to look to first, right? And so at some point, if I start feeling uncomfortable, I can stop. Just because I answered some of their questions doesn't mean that I have to answer all of them. So I can say, you know what, I think I need to get an attorney, and I'll go to one of you guys to help me, right? Okay? So it's really, really important that people are told their rights. We want to make sure it's a fair process, and it's not fair if we're coercing them, tricking them into giving a confession. They're not really given that due process under the law that we're required by the Fifth Amendment. So here's a little joke about that. It says, you shouldn't be able to afford an attorney. The state will provide one. Should you not be able to afford an attorney, the state will provide one for you. On the outside chance you should be convicted and actually go to jail, the state must provide more attorneys to endlessly pursue appeals on your behalf until you are released or the state goes broke, whichever comes first. A state can require you to prove that you cannot afford an attorney, but they will be required to provide one with you. We'll talk more about that in just a moment. So the Miranda Rights again, thanks to Miranda versus Arizona, that precedent says when arresting a suspect, that's why you see it like when you watch cops and stuff on TV, it's when they're handcuffing them. When you are arresting someone, the police must inform you that you have a right to remain silent. Even if they're asking questions, you can refuse to answer. You're innocent till proven guilty. And that anything you say can be used against you, and that you have a right to a lawyer, or one will be provided for you if needed. So that's where the self-incrimination piece comes in. Under the Fifth Amendment, you do not have to give evidence that will incriminate yourself. Remember, you're innocent until proven guilty. Raise your hand if you've ever heard someone say, I plead the Fifth. Yeah, it happens all the time, right? Like a lot of our people up on Capitol Hill do that, right? You can plead the Fifth. Okay? You can say, I don't want to answer that question because if I answer it, I'm going to give you testimony. You could use it against me in a court of law. I don't have to give you any evidence that can help you throw me in jail. We have this protection to help with that innocent till proven guilty burden in a criminal case. Because of this, if you are a defendant in a criminal case, do you have to testify? Do you have to take the stand? Yes or no? 50% chance you'll get it right. Do you think you have to take the stand if you're a defendant in a criminal case?
No.
No, you do not. Okay? Because under the Fifth Amendment, you do not have to incriminate yourself. You do not have to take the stand. So you'll actually see many defendants do not take the stand. Often an attorney will encourage you not to. Because they might be worried you'll look guilty. You take the stand. Maybe you just don't talk well and you could make the jury kind of wonder, right? The problem with taking the stand, so I did something, I'm being accused of something. For me, it's like I want to sit up on the stand and I want to tell my story and prove that I'm innocent, right? Does that seem like you'd want to do that? Yeah, like you want to be like, no, I didn't do that. I didn't kill my husband. Here's the story. The problem with that is, once my lawyer questions me, who gets to question me next? The prosecutor gets to too. Remember, there's a cross-examination. If I take the stand, I'm giving the other side the opportunity, the prosecution the opportunity to ask questions as well, and that's where I can start to look guilty. So I might be giving them their case by taking the stand. So by saying nothing, I can remain silent. I'm not giving them the evidence they need to make their case. you'll see often defendants will not take the stand, so they are not subject to that cross-examination. Now, under the Sixth Amendment, this is where we guarantee the right for criminals to have a lawyer. Again, they might ask you to prove you can afford one. And here's why this is important. You know, if you can't afford a lawyer, they have to give you one. It's not fair to have your freedom, taken away because you can't afford to have someone help you. Still, there's some controversy in this because the ones that are provided by the state, do you think they're kind of busy?
Yes.
So if you go and you sit in on trials, if you ever want to see, some of them might be phenomenal. They're not going to be making as much money as private defense attorneys are. They're not making a ton of money. They're probably swamped because there's so many cases coming in. And so even if they're a rock star, they might not be that great. And if they are great, that's wonderful, but it's not as often. The private attorneys are being paid a lot of money. They don't have to have as many cases, and they can really give it more attention. I literally sit in on cases where the public defender who is representing the individual kind of seemed confused even about the case. It was like they were looking at it for the first time when they opened the file in the courtroom. That's not where you want to be. So often people will elect to hire a private attorney, if they can afford one, but a lot of people can't. It's expensive. So that's where we see a little bit of controversy in the law again. The trial process is very similar to what we talked about in this class many times. There's a couple differences here. In a criminal case, there's something called an indictment. So what this means is just like you have to serve on a jury, that might be something you have to do. There's a grand jury you could be required to serve on. I had a friend who had to serve on a grand jury in DC. It's a month-long process. And what you're doing on a grand jury is you're determining that there is probable cause, that is likely, that it could proceed to trial. Okay? If they're charged with a crime, that there'd be enough evidence that there could be a case against them. That's all they're deciding. They're not saying if you're guilty or not. They're saying it seems like there's enough evidence that there should be a conversation, there should be a trial around it. So that's the idea behind a grand jury, and a lot more evidence is allowed in front of the grand jury. So that's the only decision getting made there. They're not in front of anybody else, and so a lot of stuff will move forward. So then what happens is an arraignment. So this is when the charges against you are told to you in the courtroom. They'll say, we're bringing these charges against you. You did this thing that was wrong, so you're responsible for these 5 crimes. And in general, you're going to argue guilty or not guilty. If you argue guilty, the judge is going to make sure you understand the consequences of that. That you could be thrown in jail, and that you're giving up your right to a trial, and that you're innocent until proven guilty. They'll make sure you're understanding what you're agreeing to. You can plead guilty. Sometimes people do that because of this thing called plea bargaining. Do most cases go to trial?
No.
No. So just like civil cases, in a criminal case, you can negotiate and come to an agreement. You can negotiate a plea bargain. And so the prosecution will say, if you go to trial, you might get 10 years in jail. If you agree now that you're guilty, you'll only get 5 years in jail. Why would someone take that bargain?
They're guilty.
So you said if they're guilty, they think they're not going to do well in trial. I mean, that's half the jail time, right? Why would you not take that? Allison, thanks. You're innocent till proven guilty. And remember, we've heard this before, even when we went on our court visit, right? Judge Greenberg said, it's hard to get 12 people to agree about anything. You're innocent till proven guilty, and it's difficult to get a jury to unanimously agree that you did something wrong. They might want to take the gamble and go to court. Depends on the person. They have an opportunity usually to plea bargain. Why would the state offer you less of a punishment? What's in it for the state? Javon, a little louder.
Save money.
Save money. So the state has limited resources. They need those for some of the bigger cases. What else? Brian, did you want to add something?
I just said time not wasted.
Time. I just told you they have a lot of cases they're doing. They don't have enough time. Just like they're limited on money, they only have so much time. If they have to go to trial, they have to prepare for that. That's time consuming. So if they can get you to agree to a plea bargain, yeah, you only going to jail for 5 years instead of 10, sure, but they might not have won the trial anyway, So double jeopardy I mentioned earlier in terms of the Fifth Amendment. If you do something wrong, a defendant can only be tried once for a particular crime. Any questions about that? If I murder someone and they say, you are not guilty, Professor Weiser, I am off the hook, right? They can keep appealing it, but once all the appeals are exhausted, I've had my day in court and I can't be found guilty of murder again later. There's exceptions to that. That's why I asked if there was questions. Anyone seen the podcast Serial before? Anyone listen to that? No one? So Serial was this podcast that's really popular. I don't listen to podcasts, so that's why I sound weird about it. but I usually have a ton of students that like to listen to it, and it was based on a murder that happened in Baltimore. Because the podcast got such popularity, they decided to look into that case further. In some instances, like if somebody lied on the stand and they find out later it was a lie, they may reopen the case. This isn't like a hard shut thing. If something wrong happened in the trial, you know, maybe like fraud was happening, they might let them reopen the case. You might want to look at Serial if you're interested in that podcast. I'm not going to show you this clip, but it's a clip from the film Double Jeopardy where you get to see, you know, this woman. She gets in trouble. She gets thrown in jail for murdering her husband. She didn't murder her husband. So he's out in the street. She decides she's going to kill him now, right? She's angry at him. And so she decides she's going to kill him. Can she be tried twice for killing him? She's already found guilty, right? So there you go, Double Jeopardy. The last piece we're going to talk about today, and then again next class we'll talk more about specific crimes, things like business crimes, theft, embezzlement, money laundering, is this idea under the 8th Amendment. We have lots of protections when we talk about criminal law. This is a big one. Under the 8th Amendment, you have a protection against cruel and unusual punishments. Cruel and unusual punishment shall not be inflicted. And so here, the precedent, you'll see this is a U.S. Supreme Court case from the 1970s. This precedent, this prior case, Furman versus Georgia. In this case, the courts define the test to determine if a punishment violates this 8th Amendment prohibition. It says if a punishment is unusually severe, if it's strong probability that it's inflicted arbitrarily, and if it's substantially rejected by contemporary society, and there's no reason to believe it serves any penal purpose more effectively than a less severe punishment, it could be considered a violation of your 8th Amendment right. When we talk about cruel and unusual punishment, we usually are talking about the death sentence. Okay, saying you did something wrong, you murdered someone, your punishment is you die. In some states, that's okay. In others, not so much. In some states, they've said this is cruel and unusual punishment. We're not going to allow it. So let me show you an example here. And for those of you that are interested, you can look at this. It's on the learning module, and I have some printed copies for you. This was an article from Time magazine called Fatally Flawed by Josh Sandburn, and it discusses a person's execution. This guy's name is Dennis McGuire, and he was being put to death using a new, untested 2-drug combination. He'd been told by his lawyers that Ohio's new lethal injection protocol could cause him to experience air hunger and feelings, so like suffocating, and feelings of terror as he tried to catch his breath. So he apologizes the day that he's about to have this death sentence. He apologizes to Joyce Stewart. She was a 22-year-old pregnant woman, and he was convicted of kidnapping and raping her, and then murdering her in 1989. So this is recent, just so you know. That sounds pretty bad, right? But some people would argue he should have died. Others will say, despite doing all that bad stuff, the way he died was not okay. It violated his 8th Amendment rights, and here's why. They push it into his veins, and as the minutes are going by, he keeps thrashing around, he's making these loud noises, and his son's watching the whole thing. So when you do a lethal injection, people don't usually just die immediately. In fact, this one took 26 minutes from start to finish. It was the longest in Ohio's history, okay, of 15 years punishment. Usually it's like 15 minutes, 26 minutes. So everyone might agree he should have died. The issue here, the controversy is, was this too much? And so in looking at this, I just want to show you really quickly a couple of things. And if you're interested in this, you can read the full article. It's definitely an interesting scenario. I like to show these graphics. This shows execution in America. So since the 1700s, the primary method of capital punishment, when someone's sentenced to death, has evolved from hangings, which we see here in blue, to electrocution, which we see here in brown. You see that was, the electric chair was the way they would kill people, to red injection. Now this article talks about some of the issues around injections. In jail, usually there's not like a qualified doctor or nurse putting that injection in the prisoner. You know, it's just one of the warden or one of the people working at the jail are doing it. So sometimes it's put into their veins improperly, and that's why it can take so long. The other big reason it can be a problem is because generally these lethal injection drugs include a drug to sedate the person, to paralyze them, and then to stop their heart. This medley means that in general these companies don't have to follow as many rules because it's like this combined drug. And most companies that are the ones making drugs to kill somebody, they don't want to advertise that, right? And so we get less and less companies providing this. And so they run out of this resource, or it's not really heavily circulated. And so it's not what we call like a clean way to kill. And so in general, that medley seems to not be working well in some of the injections done today. We've seen what happened in McGuire's case where he spent 6 minutes of kind of really awful stuff while his son watched as he died. And some people would argue that's just cruel and unusual. So just to show you, the states vary. There's 35 states that sanction the death penalty. And you'll see here the bubbles get larger depending on the state. So these are the executions done on a state-by-state basis. You'll see who had the most executions in the biggest bubble. I know it's hard to read. That's Texas. That was 515. If you look around here, you can see some of the different states. Maryland has only 5. Okay, we've outlawed it. So you can see, depending on the state, you can be sentenced to jail. Others, they'll just tell you have to spend life in prison. You're not going to have to be put to death.
What are those other 2 states with 100?
What do you say?
What are the other 2 states?
Oh, I'm sorry. So thank you. That's a great question. One of them's nearby. Virginia has 110 executions here, and Oklahoma has 111. And you'll see some of the other major ones are Missouri, Florida, Georgia, and Alabama, South Carolina. So again, some states allow this. Other states have now outlawed it as a crime under violating the 8th Amendment. Cruel and unusual punishment. Interesting stuff. We'll talk more about business crimes next class. If you're interested in that article, it's under the learning module, or I have it printed here for you.